Welcome to the Cyber Business Podcast, where we feature top founders and entrepreneurs and share their inspiring stories. Now, let's get started with the show.
Matthew Connor here, host of the Cyber Business Podcast, where we feature successful business leaders, top law firms, green energy companies, and more. Today, we have a very exciting guest, a man I've been trying to get on the show for months and finally worked it out. He's the author of You've Been Hacked, Now Who's Liable, a commercial and probate litigator at Schneider Smeltz Spieth Bell, LLP, Nick Vento. Nick, welcome to the show.
Thanks for having me, Matt.
My pleasure. Before we get too far into the show, a quick word from our sponsors. This episode is brought to you by cyberlinks.com. That's cyberlynx.com. Cyberlinks is a complete technology solution provider that ensures your business not only has the most reliable and professional IT service, but also has the right cybersecurity solutions to ensure your business stays productive and safe. And now, back to our show. Nick, thanks for coming on the show today. I have so many questions for you. Hope you're ready.
I'm ready.
Okay. So for those that aren't familiar, can you tell us a little bit about yourself?
Sure. As you mentioned, I'm an attorney. I practice at the law firm Schneider Smeltz Spieth Bell, LLP here in Cleveland, Ohio. The name's a bit of a mouthful, but as you mentioned, my practice primarily focuses in commercial litigation, represent businesses in basically any type of dispute that may come up when you're running your business. So contract disputes, shareholder disputes, trade secrets, labor, employment, real estate, things of that nature. I've been at the firm about 5 years now. I've been practicing for 7. And yeah.
Love it. So let me just jump right in. You wrote a great, I guess we'll call it article, entitled "You've Been Hacked, Now Who's Liable." What was the inspiration there, and can you give us some details? Because I thought it, first of all, fantastic article. I think great topic, but I'd love to hear from you. What was the inspiration, and can you tell us a little bit about it?
Sure. What inspired the article was we had a client who came to us who had experienced a business email compromise, a hack, as described in the article. So a business email compromise being they had a hacker infiltrate their computer network while they're in the middle of a transaction with the customer. The hacker emailed the customer, pretending to be our client, saying, "Hey, we are changing our bank account. Here's our new wiring instructions. Please pay your next invoice to this bank." The customer did that and paid about $95,000. And then when everyone realized what happened, the money was gone. And so the client came to us looking to figure out what they could do, because they had our client, in this case, they sell industrial equipment. They delivered the equipment, and the buyer had paid $95,000, but not to our client. So our client wanted the money, and the buyer's saying, "Well, wait a minute, and now you're going to make us pay twice." And so they came to us and said, "What should we do?"
Fair question. I mean, and it's, all that, it's actually really common. We're seeing it a lot on the cybersecurity side, on the legal side. And first of all, I mean, you feel bad for both sides, right?
Yeah.
I mean, everybody thought they did the right thing. Meanwhile, some a-hole in between, ran off with all the money. So, are you seeing this a lot on the legal side? How's that play out?
Yeah, it's becoming increasingly common. So we had this situation. We actually had 2 clients in the year I wrote the article in 2021 come to us with this exact issue. And that's what led to me to write the article. I mean, beyond my own sort of experience anecdotally, I know the FBI reports on this type of cyber attack fairly consistently. And the most recent report I'd read, that they had said that about $2.4 billion in claim losses were attributed to this business email compromise type of cyber attack in 2021 alone. So it sort of gives you an idea of how common these attacks have become. And I think they compared that to 2016, which they had said about there was only about $300 million in claim losses. So the number is spiked astronomically. And so, yeah, it's both anecdote for me. Oh, we have a lot of business clients. They've come to us at an increasing pace in probably the last 5 years with this type of issue. And then the data shows too that this is becoming a big issue for businesses.
Well, yeah, I mean, we're seeing so on the cyber side, we're seeing things where it used to be kind of science fiction almost. You'd see it in the movie, for instance, like the SIM cloning. You'd see it in the movie where they go up and they're like, "Oh, we've cloned a SIM. Now we get all their texts and calls." And you're like, "Oh, that's really cute," but movie fiction stuff. But turns out it's not. It's something that was reserved really for high level government officials, high priority, let's say commercial clients. I mean, just super high net worth people, because that is a very advanced thing to do, right?
Yeah.
Well, we're starting to see that since the advent of AI and all of this money flowing in, even before this, when the pandemic hit and all this money starts flowing in from ransomware, we're seeing huge stuff happen on the dark web. Like they're using high-end marketing to market services like this: SIM cloning, business email compromise, ransomware as a service. And they have like marvelous marketing. It's insane. Like actual really good video marketing of their service. I'm like, this is insane.
That is crazy.
Which didn't exist before, but now they are. And so we're seeing, like these business email compromise hackers who, prior to all of this money flowing into the let's say that industry, you had to be so technically savvy to be able to do it. Now it's so easy for them to do it, and more money keeps flowing in. Some guy without any skill can go and rent, business email compromise, technology, and boom, get all the passwords, log in, rent the SIM cloning, the whole 9 yards. It's insane. So, but let's, all that aside, back to the legal side of things. How does this play out and work? In let's say the business email compromise, for instance. So you've gone and you've sent the money. Now, really, to your question, now what?
Yeah. So to, I guess, go back to we'll sort of walk through the situation that we were dealing with, or my client was dealing with. The first thing we looked to was, obviously there's the hacker. If you can locate the hacker, that would be obviously the perpetrator. They have the money. I would be shocked if anyone is able to get to that person or entity before the money is gone. So hacker, rule them out. So next we look to the bank, and we asked the question, well, so the buyer's bank processed this transaction. They allowed it to go through where the wiring instructions didn't necessarily match up. So the account numbers matched up, but the beneficiary names were different. The beneficiary name on the wire transaction said my client's the business name, but then the account name on the receiving bank account didn't match. And we said, well, is there any liability in that there? And the answer to that question was basically no. The law is really lenient to banks. It's basically, it's sort of set up to allow for banks to process transactions using automated processing and do it as quickly as possible. And so as long as the bank has matching account numbers and confirms that, and they aren't grossly negligent in some other way, then they are probably coming out of this, you're not gonna have any sort of claim against them. So then it turns to basically looking at your customer or whoever you're transacting the business with and saying, well, do we go after them? And that's the conversation we had with our client was, do we want to go after the buyer or not? And what are our chances? What is our liability? Are we at fault here? Because our client was hacked after all. And so I can start with sort of what the legal, what the the legal maybe answer to this question is, and maybe we'll start there, and then we can talk about what the practical answer is. And this is discussed in the article, and what we found was pretty interesting is that there really isn't a lot of case law on this issue. I suspect because part of it is because the transacting business on the internet is a fairly new phenomenon. It's not that crazy new, but I think maybe in the past 5 to 10 years, it's not just your Amazons and whatever, but even mom and pop shops have to do business over the internet. It's basically how business is being done in the modern world these days. But there really isn't a lot of case law, and courts were sort of grappling with how to deal with this, because in a straight breach of contract analysis, if we go back to my example, our client's the seller, they've delivered the goods, so they've performed under their contract, the agreement that they had. Buyer pays $95,000, but pays it to a hacker, thinking that they paid the seller, our client. Technically, in a straight breach of contract analysis, the buyer is in breach. They didn't make payment to the seller, and they would be liable for essentially making a double payment. And so what I found in my research is that some courts are starting to, I think, with the idea that maybe that is not the most fair approach. It's a very black and white approach to look at it. Some courts are saying, well, wait a minute, why don't we try and apply something more equitable and more that takes into account the facts of the circumstance of the hack to see then to sort of maybe figure out liability that way. And so to do that, courts have adopted or looked to it's Article 3 of the UCC, which is the Uniform Commercial Code, and that's a set of sort of form laws that have been developed for states to adopt to make doing business across state lines more predictable. And all 50 states have sort of adopted this model code in some form or fashion. But so the courts, a few courts have said, well, why don't we adopt what's known as the imposter rule to these contract scenarios? And I can explain the imposter. I'll explain the imposter rule. If I'm talking too much, too much, let me know.
No, this is great, because I honestly think this is what people want to hear. Right there, people want to know this. So please. What's the imposter?
The imposter rule is in like I said, Article 3 of the UCC. Article 3 applies typically to negotiable instruments. So that'd be like checks, cashier checks, things like that. Not typical in contract scenarios or wire transfers. But the imposter rule states when a negotiable instrument is subject to third-party fraud, the party that was in the best position to prevent the fraud should bear responsibility for it. So basically, whoever was in the best position, whoever could have identified and stopped the fraud will be held liable. And so in, for example, the Aero Truck sales case that I described in my article, the seller was hacked. They had sold about 20 trucks, I believe it was, for about $570,000 to the buyer. Seller was hacked. So the court will say they looked at the cybersecurity protocols of both parties and said, hey, they had reasonable cybersecurity in place, but the buyer should have noticed that there was obvious signs that they were being sent spoof emails. So there was wiring instructions that were conflicting. One legitimate set was sent. Then the next day, the hacker sent an illegitimate set of wiring instructions. And then the day after that, the seller sent the right wiring instructions again through invoices. So there was multiple days in a row where they're getting conflicting instructions. I think the email addresses were slightly off. There was some typos and other red flags that the buyer just didn't pick up on and went ahead and paid $570,000 to a hacker. And in that case, the court said, the buyer was in the best position to have prevented the fraud. They should have noticed these things. I think courts will probably say at this point, businesses need to be training their employees, and you need to be trained on how to identify spoofing, phishing emails, and see those signs, and make sure you're calling your customer or your business, whoever you're doing business with, to confirm that whatever wiring instructions you're getting, it's from a legitimate source. So that's courts are starting to adopt that in these kind of cases, and that we thought that was really interesting.
I completely agree. I mean, and I think that at the end of the day, most of these things are preventable. I mean, even ransomware, you name it, with the right monitoring that's set up. And yeah, if somebody's not monitoring your system 24/7, then you're just hoping that you're not hacked. And if it's being monitored 24/7, then when there's some weird login from Lithuania and you're an Ohio-based business where all your employees are in Ohio, but suddenly this crazy login, and then emails start going out, that's stuff that should be caught. So, for us, we advise people to do that whole 24/7 monitoring, to make sure that these things don't take place. But the basic stuff, like you're saying, people should be training your employees, right? And now, do you think that those kinds of this advice is going to come? I mean, where's that going to come from? Or is it just like the industry as a whole? People should be learning this from the painful lessons, learned by others. Is that because I don't know that there's like going to be a governing body that says, hey, small business owner, you should be training your employees to identify fishy emails. Okay, this one clearly doesn't look right. Or, hey, we got wiring instructions. Our protocol should be, we should call and make sure that, to somebody that we know hey, that is indeed, those are the right instructions, right?
Yeah.
How do you see this all playing out? Is it just something people have to pick up on their own?
Yeah, I think unfortunately that probably, unless there are some sort of laws passed or regulations passed, it's going to have to be up to businesses to either be proactive in learning about listening to podcasts like this, or there's a lot of articles on the internet about these kind of issues, or they're going to learn the hard way. And a lot of I think businesses are starting to get smart to it. I think another sort of scenario too is if you want to get cyber insurance, which I think is a good idea at this stage. A lot of, I think, cyber insurance policies probably require you to demonstrate that you have IT policies in place that are up to par with what are considered industry standard, and that you're training your employees in these in how to identify spoof emails, in proper security protocols like dual factor authentication, things like that. So that, I mean, in some ways it's maybe there won't be any sort of explicit laws or regulations passed, but sort of the nature of doing business is just going to force you to keep up. Otherwise you're going to lose one way or another.
Yeah. Well, I completely agree. And, of course we do that whole training, piece. We've got a cybersecurity training thing for our clients. But I'm thinking of the legal, side of this. And then, so let's say the case goes through, right?
Mm-hmm.
And then is this something where your insurance provider is going to end up, picking up that tab? Or is this something where you're taking that business loss of the 100, 500,000, whatever it is? How does this play out legally? Is this,
The answer probably is it depends. So it'll depend on if you have cyber insurance coverage, and it'll depend if your cyber insurance policy even covers this type of hack. So I wouldn't, sort of as a practical recommendation, I wouldn't assume that because you have cyber insurance that it covers every type of hacking incident. I don't think either of our clients were covered. I can't I don't recall if the one had cyber insurance, but I think the other, this type of incident was explicitly excluded. So if this is a concern of yours, if you are, um, if sending invoices, if transacting business via email is how you do things, then I would definitely check. Even if you have cyber insurance, check your policy. You can check with an insurance lawyer too, your insurance broker, to make sure that your policy, you're covered under your policy for this type of incident. But beyond that, even if you are covered, perhaps the circumstances of the breach could lead your insurance company to deny it. So it's not a guarantee that things will be covered. And I wouldn't lean on that as a backstop to say, well, oh, we've got a pretty good, we've got pretty robust coverage. It's high policy limits. We're good. We can kind of wing it. I mean, number one, I think you're putting yourself at risk probably of your insurance company maybe denying it if your policies aren't correct. But then also, it's without you double checking, it's possible it may not be covered. But so then you're paying for it out of pocket, and that can be a costly endeavor. Litigation, like most litigation is costly, big or small. It can get very costly, and I would definitely, because of sort of the fact intensive nature of what a lawsuit like this would entail, it's going to be expensive. Trying to prove who was in the best position to prevent something is probably going to require you to hire experts, and it's that a lot of depositions, a lot of discovery, and you could be looking at 6 figures worth of attorney's fees, and then it's like, well, depending on how big the loss is, it might not even be worth it. So, and beyond that, and to go back to my example with our client. So $95,000, not really probably worth going a full-blown lawsuit. But beyond that, this was a customer of our client. They had a long-term relationship together. Do you want to hurt that relationship by starting litigation? And the answer ended up being no. And I think maybe that was true for, obviously I don't know what the other side was thinking, but it might've been true for both sides. And how that case resolved, or how that issue resolved, was that our client and the buyer just decided to split the difference.
That makes a lot of sense. I mean, and I think that, as you look at it from both of the, both parties, it's a tough one. And, especially if, I don't know why, but I don't feel bad when it's like, oh, insurance is going to pay for it. I don't know why, I guess because I don't own an insurance company.
Yeah.
I'm not an insurance underwriter. I don't know what it is. But I feel bad about, for the businesses. And I'm like, oh, it's rough, because that's either going to, for some businesses, that's going to break them. For others, it's just going to hurt.
Yeah.
I don't know if too many small businesses where they're like, oh, $100,000, that's nothing. $500,000, that's nothing.
Yeah.
That's something. So
yeah, it's definitely something. But yeah, it's definitely, it's a tough situation to be in if you're paying out of pocket for it. It's not an easy, and yeah, $95,000 is nothing to sneeze at, or $100,000, or even, I mean, no amount of money is nothing to sneeze at, depending on what size your business is. But that's kind of why I suspect that there has been so little case law. Like I had referenced before, there is not a lot of case law on this specific type of incident. And I suspect a lot of these cases end up getting resolved before lawsuits are filed because of that reason, because it's going to be an expensive fight, and there's a lot of uncertainty. And perhaps these are entities that have done business with each other for a while, and you want rather just move on amicably and rather than fight it out for years, potentially.
Well, it makes perfect sense. If we're talking about $100,000 and that's the total loss, let's say it's $100,000. Great. Split between both parties, $50,000 each. Or if each party then invests $100,000 more to fight, now the total loss, we're talking about $300,000, is spent over. So it just doesn't make a lot of sense to fight. So to your point, there's likely a lot of negotiation here, and people kind of splitting the difference and saying, fine, we both got suckered. So, your advice on business email compromise, your legal advice, and I know you probably can't give legal advice on a podcast, but what would you say to people? What should they be doing, from your perspective?
If they've been hacked or to prevent it, or
I'd say I think your advice is prevention. The ounce of prevention is worth a pound of cure type advice. Is that about right?
That's I think that's a good way to sum it up. Is you want to be proactive on the front end. Though it may be costly, I understand it's not cheap to do some of this stuff on the front end, and businesses can sort of balk at the cost, but there's a lot more uncertainty and cost on the back end with litigation. Litigation's, like I said, I think I've said this probably 2 or 3 times now. It's expensive. There's a lot of uncertainty, and both in how long it may take, the cost, and then with the law too. Not every juror. I'll say a caveat to this imposter rule, though. It is really fascinating, and it seems like a lot of courts, some courts, a fair amount of courts have adopted this approach. Not every jurisdiction is taking it up. And a case I found recently was out of the the Northern District of Georgia. They said they considered the imposter rule and said, we're not going to apply it. And so not every jurisdiction is adopting this approach. Not every court agrees. So depending on where you live, it could be different, depending on or where you do business or where your customer does business. It could be, the rules could be completely different. So there's that as well.
Good point. I mean, I read a news story about basically it was a business email compromise, and the bank actually got held liable, which was the first time that had happened. And this was just a few months ago, where they found that because the hackers had opened up it was a US based bank. They opened up an account. It was the first time they opened it up. And suddenly, they're getting this, $100,000, ish wire in, and they immediately send it out, and they do this again and they send it out. And they were like, this didn't raise any red flags for you at all. It was a brand new account. In comes this money, out goes it. And then, nothing. So no other business, nothing. And so they ended up holding the bank liable, which was a first. But I think to your point that this is all, I don't want to say the wild, wild west, but it's undiscovered territory, really. It's uncharted waters. There is no clear guidance one way or the other. So if something bad does happen, there's no telling where the court case how it might play out, right?
Yeah. And I mean, even if you do want to go to court, and let's say you're in a jurisdiction that applies the imposter rule, when I think the advice still stands that you want to be proactive, because when you're talking about the court's evaluating or a jury's evaluating who's liable, they're not gonna, if you've got all your ducks in a row and you've implemented the proper protocols. I mean, not only are you mitigating your opportunity, of this happening, chances of this happening, but the court's going to say, well, this party did everything they were supposed to, whereas maybe the other side didn't. And so if you're thinking about it on the back end too, it puts you in the best position to succeed if you are in a position where you feel like you need to litigate a claim like this.
Good point. Well, beyond just the business email compromise, what else are you seeing on kind of the cyber side of things in the law?
Essentially, I mean, just that it's becoming more beyond, I guess, business email compromises. We've had clients, who are holding confidential information of others and having that be compromised. And what are our notification obligations? How do we deal with potential liability in that? That's been a big issue. HIPAA related compliance, things like that. And go ahead.
Can we touch on that for a second? Because I think for a lot of businesses, we've got a lot of small law firms, a lot of small businesses that end up housing a lot of what the government calls PII, right? The personally identifiable information. And and their concern is that liability. If they get breached, if there's some sort of breach, what do they do? What is their liability? What, so I think for a lot of people, they take the ostrich, approach, and they just kind of stick their head in the sand, and they're like, I'm busy with other things. And let's hope that that lightning doesn't strike us. It's gonna strike. It's only a matter of time. You're in a lightning storm, right?
Yeah.
So, what kind of liability does the average small business look at in terms of, if they're breached and they have, PII, what's their liability? What do they do?
So it depends on what state you're in. Some states have more strict notification obligations than others. In Ohio, the data breach statute requires, and Ohio defines a data breach as if someone has accessed and acquired personal identifiable information. And those terms are sort of loosely defined, but if they've accessed and acquired a third party's private information, then you have 45 days to notify them. And then there's some other requirements, and other states, it's I want to say it's Vermont. One of the East Coast states, it's like 2 days or 5 days or something. So there are some very strict notification obligations, and it comes with penalties or potential class action lawsuit liability if you don't meet those deadlines. And so if you are, subject to that kind of attack, then I would definitely recommend reaching out to a lawyer so they can help you understand what your notification obligations are. And it's not necessarily, where you're located either that dictates that. So if you have clients, let's say you're an Ohio business and you have half of your clients in Ohio and half of your clients are in California, it's based on where those people, their information is located is what's going to apply. So you definitely, sticking your head in the sand is not going to make it go away, especially if people's information ends up on the dark web and they find out from their credit card company or however that hey, how did our information get compromised? And they're able to trace it back to you. And then that we've had actually, our firm's been on the plaintiff side of a class action lawsuit like that. So yeah, burying your head in the sand is not the solution I'd recommend.
Right there with you. So let me ask you, what are some common sense actions that a business can take to protect themselves? What's your advice there?
I think we've touched on a few of them, but definitely training your staff or employees, if you're a business, to how to identify spoof emails and requests, and on what the proper security habits are for your email accounts or your computer accounts, such as password changing, dual authentication, having those systems and that training in place, and making sure you're reinforcing it and not just handing out a packet and hoping that everyone reads it. Reinforcing those policies as frequently as it makes sense. And then beyond that, if you're transacting business on via email, which is sort of the circumstances in which these business email compromises arise, I think you want to try and have policies in place on how to process those transactions. So training your accounts payable, accounts receivable to, if they're getting change of wiring instructions, emails from another party in a transaction saying this is the protocol you need to follow. You have to call somebody at the business using pre-existing contact information, things like that. We've been talking about it, or we've been advising clients to consider putting those terms. I mean, so not only having internal controls, but considering putting those terms in agreements with your customers to say, this is how payment. So payment is, let's go back to the $95,000. It's going to be paid via wire. And then maybe as a subclause saying, if our wiring instructions, or if our bank, here is how if there is any circumstance where there's a change in bank account information, this is how it's going to be communicated, and this is how you're going to confirm it. We're going to confirm it. And that, I think, not only makes sure everyone's on the same page, but that could help you in a contract dispute if that were to come up. And then finally, you want to have the proper IT, like software and like anti-phishing software, filtering, those kind of things, that software in place as well beyond the training. So I think that's the best advice I can give to prevent these kind of attacks.
Wow. You know what? It just goes to show you, this is why it's always important to talk to lawyers, because that just having that bit in the contract, that's brilliant. I mean, I think, and look, we love small businesses. I'm a small business. I kind of come from a long line of, but not even a long line of small business owners, but a short line of small business owners. And so I think, and I see the world in terms of small business. And I think all too often, so many small business owners forego, proper legal advice, because it'll be cheaper. They'll save some money. No, you won't. In fact, every dollar you spend in legal advice, in good legal advice, I think is worth $10, to you, easy, because you get the wrong advice that you gave yourself. You think you figured it out when you don't understand the way the game is played, and you're like, I'll just play it. Oh shit! I went to, now you go to jail, do not pass go. It's like, oh crap, right? No,
Yeah.
much better to get the right advice. Now you're playing the game properly, and you're saving a fortune. So that little bit about just putting it in your contract. This is where you wire it to, and if we change those, this is how it's going to be done. And so if the other side screws up, you've made it pretty clear. You had it in your agreement. This is how it's going to be, and you kind of won right then and there, right? I mean, at the end of the day, it's the other guy who's going to have to pay because you spelled it out in your contract, right?
Yeah, and certainly, and that's, I think that makes a lot of sense, and exactly. And it doesn't matter what the prevailing laws in your jurisdiction, you have a contract term that you can point to and say, well, this was spelled out, and you didn't follow it. And I think that's a good way to protect. And I mean, you're 100% right about the cost, and I feel like we should clip that last part and put it on our website, maybe, because
it's yours.
It can be costly, and sometimes even in negotiating can be uncomfortable, and you're worried about jeopardizing relationships. And obviously, circumstances are different with each client and the customer they're dealing with. But it's at the very least worth considering. Those kind of terms if that's something that you're worried about, or if all you do is transact business over the internet, which I think that's what most businesses are doing these days. So it's something to at least consider, I would say.
I completely agree. So if you had just one thought that you wanted to leave the audience with, what would it be?
I think we've touched on it a few times, but basically it's be proactive in sort of dealing with these cyber attacks and trying to put in the right protocols and policies to prevent them. The threat of cyber attacks are the new reality of doing business in the modern world, whether you're a large or small business. Cyber attackers don't discriminate, and if you're hacked, sort of the prospects of recovery are at best speculative and expensive. So my best piece of advice is to be proactive, contact your attorneys, or contact an attorney, contact your an IT company, cybersecurity company, and say, what are the best practices we can put in place now to prevent something like this from happening?
Well said. Well, I know you said we kept going over it, but I think that repetition is good for a developing mind. So, for all those people who've heard it multiple times, let this be yet another. So no, I completely agree. And I think I can't thank you enough for coming on the show today, Nick. But before we say goodbye, can you tell everybody where they can find out more about you and your firm?
Yeah, sure. We've got our website is so the name of the firm again is Schneider Smeltz Spieth Bell. We're based in Cleveland. It's a full service law firm based in Cleveland. So We do full service, meaning we have corporate practice group, we have estate planning, litigation, which is what I practice in, and then a family law group as well. You can find us on our website. It's sssb-law.com. So S as in Stephen 3 times, B as in boy -law.com. Sorry, the name is a mouthful and the URL is a little funky. Law firms are starting to cut names down a little, and I think we're a little behind on that trend. But that's where you can find me. I've got a profile on the website, and like I said, it's a great firm, and yeah.
All right. Well, we'll put links to all of that, including your article in the down below. And so again, thanks, Nick. It's been great having you on the show.
Thanks for having me.
Pleasure.
Thanks for listening to the Cyber Business Podcast. We'll see you again next time, and be sure to click subscribe to get future episodes.